Hello, everybody. My name is Caitlin, and I will be discussing with you today about testamentary capacity or Psychology 546. We'll be discussing why this is important, what exactly it means, what are the implications of it, why are we even talking about it in the first place. So let's get started. Let's just start with the basics. What exactly is testamentary capacity? As explained by Melton, testamentary capacity refers to the legal and cognitive ability of an individual to make and alter a valid will for themselves. Um, as far as I'm aware, we are only talking about doing one for oneself. We're not talking about executing one for somebody else or anything like that. But I would say the guidelines would still follow the same. Melton discusses testamentary capacity in the context of mental health law and the cognitive/legal standards that are involved in making those decisions and putting one into fruition. The key elements to testamentary capacity that we are wanting to make sure that an individual is aware of during the execution of a will. Number one, we want to make sure that the person understands the nature of the act that they are executing. We want to ensure that they understand that they are making a will in the first place, what even a will is, and we want to make sure that they understand that it dictates their property and how will be distributed after their death. So again, we just want to make sure they understand the basic fundamentals of what it is that they are doing and what a will is. Second, we want to make sure that the person understands the extent of their property. We want to ensure that they have the capacity to understand what assets they own, what those assets mean, what they look like, what it looks like passing it down onto somebody else. So that can include their bank accounts, real estate, vehicles, other valuable possessions, things that anything that they're wanting to put into a will, we want to make sure they have the capacity to understand what exactly that is and what it exactly looks like when passing that down. Continuing on, third, we want to make sure that the person understands the relationships that they have with the person that they are putting on the will. We want to make sure that they are aware of the family members or persons that they're trying to assign as a beneficiary or an heir of their property. Do they understand that their daughter is their daughter, their husband is their husband? We want to make sure that they have a full cognitive understanding of whose name they're even putting down to inherit the property. Unfortunately, there are many vulnerable adults that get taken advantage of as a result of many variables. And this is just one of those things to make sure that some random person or someone who is trying to take advantage of um, is not. Number four, we want to understand, we want them to understand the potential consequences of their wills. Do they know what the pros and cons are of implementing a will? Do they understand what ramifications the distribution of their property and inheritance can have on the family or on the person? It is a big legal decision and it is legally binding, as we've talked about. So we want to make sure that they understand from start to finish what it looks like and that they understand what it means to put one in place. So why are we talking about it at all? Why is testamentary capacity important? Number one, we want to ensure the validity of the will remains in place. If an individual lacks the necessary cognitive ability at the time of making a will, the court may later declare the will to be invalid. So this can result in significant challenges and complications for those affected by its contents. So if you've left all your property to a sibling or a spouse or child, we want to make sure that those people are not affected by it being done while under the influence or when they were not cognitively stable, to eliminate as many consequences or errors that may occur, as death itself is already a hard process, and let's try to make it as easy as possible, because having to deal with this outside of that can make the process and grief more difficult. The second thing is we want to protect the vulnerable individual that is even executing the will in the first place. Testamentary capacity laws serve to protect the individuals, particularly the elderly or those with cognitive impairments. Um, we see those more often, typically because those are the populations that are writing wills as they're nearing death, or they may suffer from something that they know will maybe shorten their life expectancy. So we want to make sure that those individuals, again, that are executing these wills are protected from exploitation and ensuring that their assets are distributed fairly and accordingly to what their true intentions would be if and when they were cognitively sound, if they happen to not be at the time of executing their will. So what are some factors that can impact testamentary capacity? Number one, we want to assess for any mental illnesses. Conditions like schizophrenia or other major mental illnesses can impair a person's ability to understand and execute a will soundly. We want to check into any clinical diagnoses that a person may have. Are they on medications for said diagnoses? Do they have good days? Do they have bad days? Is it pretty much in check, or are they kind of constantly battling with their mental illness? Number two, I've kind of put separate from number one. To my knowledge, the law views this as kind of the same thing, but I think it's important to highlight it separately simply because schizophrenia can be like treated with medications and managed through medications or therapy, or just cognition that you have it through a diagnosis. Unfortunately, with dementia and Alzheimer's, that is not something that can be managed through medications. And sometimes, unfortunately, the person doesn't even know they're suffering from it in the first place, as they've declined so quickly, or they just don't remember when they received this diagnosis. So I think it's fair to put cognitive functional decline also as a factor that we should be looking out for. Another thing is we want to assess for the influence of any drugs or alcohol at the time that a person is executing this will, as obviously these are things that can be mentally altering. We can give them time to sober up, which would allow them the capacity to do that, but we want to make sure that they are not coming in drunk as a skunk trying to do this and making decisions that they may not do in a different mental capacity. Continuing on, medications. This is also something we could put under the umbrella of being under the influence of something. There are some medications that can be very body and mind altering depending on what it is that you are medicated for, the side effects can be. So we want to make sure that the medications that a person is on does not impact, are they able to get off the medications for any reason for a short span of time to execute something like this? If they cannot, how can we gauge it and kind of go from there to make sure that this person's still able to do that on said medications? Brain injury is one of the last ones. TBIs can obviously impact cognitive abilities, resulting in the possibility of effect to the execution of their will. Not all TBIs are like this, so it is a case-by-case basis. So we want to ensure that we're assessing the cognitive abilities of that TBI and kind of medically from a medical standpoint. So Melton's emphasis is that we want to ensure that we're assessing functional abilities over diagnosis, that a psychiatric diagnosis alone does not necessarily mean that a person lacks capacity to do these. They're still a person, they still have the rights to be able to execute something like this, and we want to just focus on the criteria that we're going down to ensure that we're staying within those lines, that everybody deserves it, so we want to make sure they're doing it to the best of their ability if they can do it themselves. Task specific and time specific, we want to make sure it's, when we're gauging it, that it's relevant only to the making of the will and nothing else, and that it's time specific. We don't want to gauge that somebody was diagnosed with dementia or something after a will was executed. It's just completely irrelevant. We only care about the cognitive capacity when the will is being made. Presumption of capacity, we want to, a lot of law presumes a person has the capacity unless proven otherwise. I say another way to phrase this is innocent until proven guilty, cognitive unless proven otherwise. Well, we don't even start the process of assessing somebody for cognitive decline until it's an issue that's brought up. We just kind of assume as a population that the people around us are of sound mind just like us. The forensics implications that he advocates for is evaluating the testator's cognitive abilities directly tied to the criteria that we've discussed on the previous slides. We want to make sure we obtain as much collateral information as possible from medical records, interviews with attorneys or family members, because that gives us additional insight into somebody's capacity that the person may lack themselves. And we want to avoid over-reliance on global cognitive tests if they don't directly address the legal standard that we're trying to adhere to at hand. It can get out of hand. People kind of go off the rails and assess things and maybe more deeply than they need to. In conclusion, our exploration of testamentary capacity through the lens of Gary B. Melton's work serves a critical purpose not only in understanding how legal and psychological principles intersect, but in reinforcing the importance of protecting the individual autonomy. We only care about the person and their well-being and the aftermath of that well-being. By focusing on functional abilities rather than diagnostic labels, Melton reminds us that mental illness alone does not disqualify someone from making meaningful, lawful decisions about their property and legacy. At the end of the day, they're people just the same as you and I, and we could one day be in their shoes. So we want to make sure that there are things in place to protect us as well. We also want to make sure that it's vital that clinicians, legal professionals, and evaluators understand that, what this looks like to assess with fairness, accuracy, and respect for the rights of those vulnerable individuals. So ultimately, the goal is to ensure that the will reflects the true intentions of those who create them while safeguarding against exploitation and influence. By understanding and respecting testamentary capacity, we uphold both the law and the dignity of those making some of life's most personal decisions. And that is my reference. And thanks so much for stopping by and sharing this with me. Have a great day.